Hey, I'm estate planning attorney Paul Rabalais, and in this video, we're going to talk about how to revoke various estate planning documents. Okay, so sometimes people will get their legal affairs in order, they'll establish some kind of estate planning program, and then one day they'll say, uh-oh, based on some change in family circumstances, may have had a falling out with someone that you either left something to or appointed to handle certain matters for you in the future, or perhaps someone that you named to have a role in your estate no longer communicates with you, or could be on drugs, or now could be in jail. You're thinking, you know what? I cannot have my estate set up this way anymore. I need to cancel or revoke this immediately. So when someone wants to revoke estate planning documentation, let's take a look at the various instruments and the most appropriate way to revoke them. Okay, so I'll start with someone wanting to revoke their will, or their last will, or last will and testament, whatever you want to call it. So when most people don't like the terms of their existing will, most will sign a new will that has language in it that states that it automatically revokes any prior will. But in absence of that, if somebody wants to just revoke their will and treat it as that will never existed, and if they do that, then the state laws govern who gets their stuff. But nonetheless, some people want to revoke their will anyway without signing a new one. So there's a couple of different ways to do it. You can, and again, all of this is your state law may and very likely is different. I'm an estate lawyer in Louisiana, so you have to really understand your state law regarding these revocation rules. But if you have a will, the way in our state to revoke it is either physically destroy the will or have it destroyed at your direction. You can sign a revocation of the will. It has to be in the proper form, notarized and witnessed by two people. Or you can identify and clearly revoke the will by a writing that's entirely in your handwriting and signed by you. So that's another way to revoke it. So again, most people just get a new will done that automatically revokes the old one. But if you just want to revoke it before you get a chance to do a new one, that's the way you do it. Next, I'm going to talk about how you revoke a power of attorney. It can be a little bit tricky because sometimes people sign powers of attorney and copies get made, copies get distributed to what's called your agent, and now the agent is distributing copies of your power of attorney to various third parties and may even be attempting to use your power of attorney. So I'd say if you signed a power of attorney and you have the only original and no copies were ever made, then it's safe just to destroy the original. But it's likely that copies have been made, so you have to take it a step further. And again, with powers of attorney, you're often dealing with financial institutions, with banks, with brokerage firms. You're often dealing with real estate issues, an agent on your power of attorney, buying and selling real estate on your behalf. So one thing you'll likely want to do is sign a formal revocation of a power of attorney. It's notarized, it's witnessed. And then you do two things with it. One, you record it in the public records, and that puts third parties on notice that, hey, I've revoked my power of attorney, and now that person you had named in the previous power of attorney won't have the authority to act on your behalf because you can rely on that filing in the public records that you've revoked it. Another thing that you should do in addition to filing it in the public records is send a copy of that revocation to anywhere you think that your previous power of attorney or a copy of it may have been presented. So if you have a bank account at ABC Bank and you think they have a copy of your power of attorney, well, you darn sure should send them a copy of the revocation so they're clearly put on notice that you've revoked your power of attorney. All right, now let's go on to how you revoke a living will. Remember, a living will is that kind of end-of-life decision where you state how you'd want to be treated if you're in that profound vegetative state, terminal and irreversible condition, no chance of recovery. Sometimes people say, you know what, when I signed my living will, I didn't want to burden my family with having to make that decision. I wanted to go ahead and make my decision, but based on some changes in circumstances, I've been in and out of the hospital, I now know how things work. I want my family involved in that decision, and I just want to revoke or terminate my living will. So I kind of get a kick out of our living will statutes that says you can revoke your living will either by having it canceled or defaced, or this is the one I get a kick out of, obliterated. So you can revoke your living will by obliterating your living will. Or you can burn it, and now we're getting a little violent with these living wills here. You can tear it or otherwise destroy it, either by you or by some person at your direction. So I've never seen anybody obliterate their living will. I have suggested on many of my videos that you obliterate the like button. That way YouTube shows our videos to more people, which is awesome. But I've never seen anybody obliterate or burn their living will, but that's one way to revoke it. You can also revoke it by doing a written revocation, expressing the intent to revoke it, and you have to sign and date that. And you can also revoke it, there's a permissible revocation. That's an oral or nonverbal expression by you of the intent to revoke the declaration. Again, the doctor will make a note of that in your record. And if your living will is filed at the Secretary of State, some people file or record their living will at the Secretary of State. That way hospitals can check with the Secretary of State to see if you have a living will. So if you've filed it with the Secretary of State, you can revoke it by filing a written notice of revocation in that office. So that's how you revoke your living will. And then the last thing that I'm going to go over is how to revoke a trust. So you can only revoke a trust if you've reserved the right to revoke or trust. If you watch enough of my videos, you probably know that all trusts are either revocable or irrevocable. And, barring unusual circumstances, you can't revoke an irrevocable trust. So if you want to revoke a trust, the trust has to be revocable. But let's assume that's the case. What do you do? So in order to revoke a trust, the typical way to do it is a formal revocation document gets prepared, you sign it, you date it, it's notarized and witnessed. It's what's called an authentic act. So that revokes the trust. And what's the effect of a revocable trust? Well, the effect is that the trust fails and the trust property then reverts back to the settlor or the person who set up that trust and transferred their assets to it. So a little kind of a mixed bag here of rules based on the instrument and the particular rules that apply to that instrument. So if you're wanting to revoke some type of estate planning instrument that you prepared, it's real important that you check with your state rules as to the particular rules applied to that apply to the particular instruments. Okay, so I already asked you to obliterate the like button. I'm also going to ask you to hit the subscribe button and the notification bell. That way you won't miss anything. I hope you've half as much enjoyed watching these videos, or I hope you've enjoyed, I'm not saying it right and I'm not going to do this over. I hope you've enjoyed watching this video half as much as I've enjoyed making it. We'll see you next time.